Bismillahirrahmanirrahim. Assalamualaikum warahmatullahi wabarakatuh to all my Muslim students. Hi everyone. I would like to continue with our next lecture. This is our last part of the elements of the contract. We have the other elements of the contract. Okay. Now let's look at the learner outcome for part 1. For this topic, for this element of the contract, I I would like my student to at least identify the element that form a valid contract, but this one will be considered as exceptional from the offer, from the acceptance, and from the consideration that we have learned before. Okay, there are few elements in the contract. There are few elements to form a contract based on the statute that is contract. There are also elements that have been only highlighted in the English common law, where we have to refer to the English common law to explain further detail, because they are absence of the principle in the contract act. Okay, now I would like to go to the first element and the other elements of the contract act. We have to look at the scenario. If let's say in the scenario mentioned about the issue whether they have the intention to create legal relation, then only we discuss about that. If they say there is no issue, then you don't have to explain whether they have intention or you don't have to. They have intention or they don't have intention. Basically, when we talk about intention to create legal relation, we have to refer back to the principle either the agreement is a contract, or whether we have to check whether the promise will lead to the contract or the relationship on that. Okay, an agreement alone does not necessarily create a legally binding contract. If you remember, we have seen the relationship between agreement and the contract earlier in the introduction of the contract. Basically, if you would like to check whether agreement plus agreement is a binding contract, we have to make sure that they are consideration. Okay, and we also have to check whether the agreement has the intention between the parties to create legal relation. It is not necessarily the content itself. Okay, now I would like to go to the first one. If you look at on the right hand side, the law also requires evidence that the parties intend to create a legally enforceable contract. So look at the next slide. Intention to create legal relation basically had been stated in the formulating to form a valid contract. Basically, if you refer to the contract act, we did not have the specific topic on this one. So in existence from the principle of English common law, we will refer to the English common law to identify whether the agreement is considered as valid contract based on the issue of intention to create legal relation. So number one, when we have the business agreement, that is considered as the intention to create legal relation, or maybe another category is under social, domestic, and family agreement. Okay, we will look at one of the example. For the business agreement, let's say you are making buying and purchasing, selling and purchasing. So that one will be considered as business agreement that shows that you are actually seriously would like to join the contract. Okay, on the right hand side, in terms of social, domestic, and family agreement that have been settled in the English common law, this one are referring to the parental issue. Parent is responsible to the kids, and then family agreements like marriage, that is showing that intention to create legal relation. That's why there are certain issue where, let's say, the marriage issue like divorce, so they have the letter, they have the formality to show that okay, we have actually taken the responsibility to take care of each other for example in terms of the marriage. Okay, number two, in this topic we are referring to the term certainty. This one had been highlighted earlier under the topic of the offer and also the topic of the acceptance. Offer must ensure, in giving the offer, we have to make sure that the word that have been used is certain, if you remember previously, we are talking about the horse. One person is selling the horse by saying that, okay, if the horse is lucky to him, you will buy. But you did not be able to explain what is the meaning of the lucky in terms of the words. And then the other issue in terms of the certainty, if you remember last time, the acceptance must be certain, the acceptance must be absolute. So the word that need to be used must be clear enough so that the contract can be properly considered as valid. The term of the agreement cannot be vague but must be certain. This is also one of the requirements where uncertain can lead to the void as referred to Section 30 in the Contract Act 1950. This issue had been clearly explained in the Contract Act. So if you find the word that in the word in the fact of the study or maybe the case study, the problem solving question that is really uncertain, where uncertain also referring to something that is questionable, people do not understand, the word is not clear, vague, this lead to the void contract. Void means cancel, you cannot continue. Okay, next one, in terms of the capacity, the parties entering into contract must be competent. You will see the word competent here in section 10 Contract Act. Competent to the contract also referring to the legal capacity. The word competent, legal capacity, they are referring to the same thing. When we talk about capacity, we always referring to the age of the majority. We also referring to whether you are sound mind. Sound mind means you are not having any mental issue. We did not have any issue of the mental disorder. So there are two keywords that you can take note here. Number one is sound mind. That means you are in the good condition, sound mind. And then another one is in terms of the age. Okay, so the age of the majority, as what we discussed earlier under civil and criminal law explanation, we are referring to the 18 years old and above. Let's say you are having the contract with the minor, there are exception on that. Okay, so on the right hand side, parental relationship, contract, scholarship and contract insurance. These three are the exceptional of the category of the contract that is allowed below 18 years old. Okay, but principally on the left hand side, the age of majority shall be 18 years old. Okay, what does it mean? That means if you have the issue for the parental relationship, for example, when the parent has divorced, okay, the the kids will go to the kids may require to choose whether they would like to stay with the mother or the father. So, or maybe the court had been given the decision, okay, you are allowed to take care of this child. You are allowed to take care of this child, whether the husband or the wife. Okay, so that statement or that contractual relationship is considered valid. Okay, another one, you always see that the student in the primary school or in the secondary school has the contract of scholarship, and then that is a contract, right? But then that one is minor. So whether that contract is valid, yes, the contract is valid. And the other one is contract of the insurance, that are also some exception for that. That's why sometimes I think the latest news a few years ago, I think since 10 years ago, we have the insurance that cover the baby since in the mom's tummy. Okay, so sometimes once you go out, once you are in the world, like when the mom is just giving birth, the coverage of the insurance already started. So that one is allowed. Okay, there are exception on that. Okay, now let's look at the explanation on the capacities of the parties. There must be at least two parties in every contract. As what I told you before, we cannot say that I am having the contract to myself, then I write something, this is considered contract. There is nothing there is no such thing to show that the capacity of the contract is the contract between yourself. No. Okay, and then these parties must have legal capacity to enter to the contract. For example, as what I did mention, they must be in sound mind, and they also must be the the age of the majority, except for certain type of the issue. Okay, and then according to Section 11 of the Contract Act, there are two types of people who are not competent to enter the earlier contract. This is what I did mention. When we mention that the contract must consist of the people that is unsound mind, that is sound mind, that means if you are unsound mind, that means you are not allowed to enter to the contract. The person who are not the age of majority, basically also not considered as having the legal capacity or not competent to enter into the contract. Okay, this is according to the Age of Majority Act 1971. There are few adjustments on this one. I think 1953, and then earlier you can see the Age of the Majority Act in 1963. But until now, the age of majority are referring to 18 years old. Basically, the minors below the age of 18 are not allowed to enter into the contract. Okay, but there are some exceptions to this rule. I did mention earlier the first three are basically very basic type of the contract that are allowed. Okay, but then you can see the list of the exception for the legal capacity. For example, the contract to marry, okay, the contract for the necessaries, contract of the scholarship, contract for the insurance, and also employment of the young person apprentice. This is basically the last one. Are basically based on the voluntary. Okay, now let's look at the word necessary. Contract for necessaries. Some people sometimes the author use the word necessities, so they are actually referring to the same thing. Necessaries are the things which are essential to the existence of the reasonable comfort of the infant, the food, the clothes, education, and lodging. So basically, this is considered as implied contract between the parent and the kids. Okay, necessary suitable to their condition in the life means the minor should be looked at within his circumstances and the station of the life on what she or he need in the life, where that one is required to be fulfilled by the parent. Necessaries may be varies according to the position of the particular individual. Okay, what is the meaning of this sentence? If you refer to this sentence, maybe if you refer to the level of the people who if you refer to the kids who are actually the son of the royal and the kids who are normal people like us, so of course the necessaries for them are different. Okay. Okay, now let's look at section 69. If a person incapable of entering into the contract or anyone whom he is legally bound to support is supplied by another person with necessaries suit to his condition of the life. So this one can be debated, suit with his condition of the life. This is what I did mention. If you are maybe stay at the rural area, maybe you stay at the urban area, maybe the requirement is a bit different. The person who has furnished such supplies is entitled to reimburse from the property of such incapable person. So this is example of the agreement. Actually, if you refer to the first point and the second point and the third point, this is the one statement in section 69. I break down into three to highlight the issue that we would like to focus. So you can see the first highlight here is legally bound to support. Number 2, necessaries. Number 3, reimburse. That means you can claim back. Okay, now let's look at the formality. There is no requirement at the common law that a contract should be in a particular form. Okay, you did not see any requirement that basically that this is in general. In the particular form means it must be in writing. It must be in this place. No, although important contract or contract is complex, some of the requirement of the contract required the contract to be in the written form. For example, if you look at construction contract, it is one of the requirements to show that the contract must be in written form. So basically, in general, a contract can be made orally, it can be made by writing, and it can also be made by conduct. If you remember the last topic under offer and acceptance, I divided the discussion into group 1 and 2 and group 3 and group 4. Brojan versus metropolitan metropolitan case before, that shows that actually when the person refuse or deny the existence of the contract, but you keep selling and buying, okay, but without formal agreement, you still consider as having the valid contract because you keep doing that. Okay, so that is actually the contract by conduct. Right, the Contract Act itself has two provisions that require the agreements to be in the writing form. Okay, so there are exceptions for this particular issue. Number one, agreement made in the account of natural love and affection. This is actually referring to marriage. Okay, even for Muslim, we also have to fill up the form, we have to sign, and then for non-Muslim, you can see that they are willingness to be the husband and the wife. So that is the meaning of natural love and affection. They are contract of that. That's why if you look at recently, there are a lot of issues that bring in the civil court, showing that the girl may sue the future husband for cancelling the future wedding ceremony, or maybe cancel to become the husband. Okay, because maybe earlier you already have the agreement on that, you already have agreed that you will become the husband and wife, but suddenly you divorce. That also can bring the issue for litigation to get the compensation. And basically, when we talk about natural love and affection, let's say there are issues of divorce, there are issues where you would like to get something from the husband or the wife, from the will and so on, that required the contract to be in written form. Okay, number two, agreement to pay statute barred debt. This is basically by referring to the loan. A lot of people nowadays, have to continue the life buying the car with the loan, buying the house with the bank loan. Okay, so there are requirements that every time you are making the commercial loan, that means dealing with the bank or dealing with any bank or corporate, or maybe I think some corporation regarding to the to the debt, it is required to make in the written form. But there are arguments whether you understand what had been signed or not. That is another issue. So for the above agreement, it will be invalid if they are not made in writing. Okay, so that is the basic content of basic type of the contract where it is required to be made in formality. Okay, all contracts are subject to statutory formality. For example, the statute of fraud and also parallel evidence rule. Parallel evidence rule are referring to some issue of the criminal. For the contract to be valid, both of these statutes must be followed. That means if they are statute saying that it must be in writing, statute means whatever that is enforced legally binding by the law in written. Okay, for example, Contract Act is the statute. So if the Contract Act stated that this one must be in writing, so we have to follow that. So that is basically the relationship. The statute of fraud has been adopted in the nearly every state of the country, required certain classes of the contract to be in writing and also to be enforceable if there are any issues of the fraud. Okay, we also have the issue to consider contract involving the sale of the good. Okay, for example, for 500 or more, the contract for the real estate and contract with the and the contract cannot be performed within 1 year. So this is one of the example of the formalities that required to be considered, because this is subject to the statute as mentioned in the Statute of Fraud 21. Okay, there are also another requirement, for example, commercial construction contract that required the contract to be informal. That's why after this, when we finish the topic for the contract, basic law of contract, we are going to focus on the construction contract. You will see that construction contract in Malaysia and in basically all the country required the contract to be in the formal way. Okay, in the formal means you have to write down. You must have the written information. Except if you are hiring something, if you are hiring someone for your own house, for your own private project, that is different. Okay, what we are referring is the commercial project where we are dealing between the company and the company of the client with the company of the contractor, company of the client with the government, for example. That one required to be referring to the statute, that required to be written informal. Okay, any contract that is subject to the statute must be in writing to be enforceable. That means if you did not form a contract with writing, the contract can be questioned and it may not be able to be continued. That is the meaning of to be enforceable. Okay, so this is what I did mention. General rule, when a written contract is in place between the parties, it must contain the entire agreement between the parties. If you have any amendments, it must be also done in the writing, especially amendments in the terms and condition. Okay, now as we look at the issue of consent, there are two issues of the consent that we would like to go through. Number one is mutual consent, and another one is the free consent. The issue of the mutual consent will be highlighted here. The issue of the free consent will be highlighted in our next topic. Okay, what do you understand with the word mutual? Mutual consent are referring to the meeting of the mind, means you are having the similar understanding of the contract. Okay, now look at the example here. If you look at this example, a contract for the sale of the Mustang. Okay, look at the word Mustang. If you are having the knowledge about the car, you will know that Mustang is actually sport car. Very, very famous, expensive and good car. But let's say you are talking about Mustang, but the other people think something else. So once you inform the other person that you are thinking that you are buying something else, the contract is void. Once the contract is not having the mutual consent, the contract is void. Okay, look at this one. For example, contract for the sale of the Mustang. The buyer thinks that he will obtain a car, and the seller believes he is contracting to sell a horse. Maybe there are scenarios where the horse is named as Mustang. So in this case, there is no meeting of the mind, and the contract will likely to be unenforceable. So what happened when you already signed the contract? The contract is void. You cannot continue. Okay, let's say you already signed the contract, the buyer already signed the contract, and then they already agreed earlier in the oral form. So when they want to sign and meet to change the things, okay, one would like to pay, another one would like to give the car. So when he think that, oh, this is actually not car, or this is not actually the horse, so at that time the contract is void. Okay, this is the example. If they think that they would like to get the car, but actually the other person think that they will get the house, or maybe if you did not listen carefully, you think that you are going to sell the horse, but another one you are going to sell the house. Okay, but as what we know, this one can be misinterpreted because the horse also very expensive. I think there are cases. I have heard one of the documentary, a very good horse. This one can be like 40,000, can be like 30,000. Okay, so thinking that these people may have the horse that's, within the boundary of his or her house, the people may think, oh, you would like to sell your house or you would like to sell your horse. Okay, so there are also the issues that are the issues of the mutual consent that we have to consider. Right, so basically that will be the elements that we have to consider in forming a valid contract. Okay, class?